Hi everyone, welcome to episode 57 of the Immigration Lawyers Podcast covering September 4th through September 11th. This podcast, normally start with the news and then just practice tidbits and little things like that to help and things I've been thinking about. It's going to be focused on the latter part rather than the former because not much news has happened other than the big news of DACA being taken away, as well as the employment-based immigrant interviews, as well as that interview requirement also goes to relatives of refugees and asylees filing Form I-730. But we're going to focus on a lot about practice management stuff. Recently, I've been getting a lot of emails from people who aren't immigration lawyers, so I want to reiterate this is intended for immigration attorneys, not for regular people, and anything spoken about here is not legal advice. Without further ado, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. I just spoke about earlier, deferred action got repealed. Now the issue then comes is, what do we do about people who have I-131 and advanced parole pending? Well, I think they're going to be denied and they're going to reimburse the funds, but people who already have advanced parole are permitted to leave and come back, subject to CBP issues. Now, I've had people who contacted me who had advanced parole 6 months ago. Even though they filed for and got it, they're still afraid to leave. So if they're afraid to leave then, I wonder how many of them will be afraid to leave now. It does take some courage. I haven't heard of people having problems going and coming back, so I don't think that technically should be an issue unless you have certain weird stuff in your history, for example, criminal history, or maybe if there's some errors in the system, which is even more rare. But it's a risk people have to take. But if you have an immediate relative situation where the DACA recipient also has a spouse, a U.S. citizen spouse, it might just be worth it to do that instead of going through getting waivers or constant processing and the like. Now, there was a kid in the news that came a couple of weeks or months ago where he was at the border, a DACA student, a DACA recipient, and they caught him at the border and deported him because he couldn't find his DACA paperwork on him and they didn't believe him. He was allowed to re-enter in the U.S. on advanced parole to be able to deal with the deportation proceedings against them, and I think he filed a lawsuit or something like that. So that's happening. It was weird because I would have people in the last year or two who were DACA recipients come to my office and they wouldn't keep proof of deferred action on them. And it's very vital they do that, even with the amount of time that's left. If you have a valid DACA, the client has to keep it on at all times. It's too risky to travel, especially near border towns, without it. It's more important than identification or credit card at this point under this administration. So a couple of big news things happened as well that are for immigration attorneys and clients. One is the visa bulletin was updated for October, new calendar year or fiscal year, and there are huge changes and updates. For example, in the EB-1 category, all the stuff that was backed up became current. In the F2A category, I'm assuming other categories too, but I immediately saw this one. It jumped months ahead. For example, a spouse of a green card holder had like a 4-month jump. I think it was in April or something, more than 4 months. So a lot of cases that looked like they were going to take a few more months till their time would come actually came up. I haven't looked at the other categories, F3, F4, but I'm assuming those moved up some as well. So keep in mind, look at your visa bulletin cases that are pending, and maybe they're coming up sooner than you expected, and you can expect starting on that consular work sooner than you thought. The big deal that's happening right now is they're updating the Foreign Affairs Manual, the FAM, and some of the changes are pretty major, and I can't fully understand how it's going to play out. For example, they updated the 30, 60, 90-day so-called rule, where if you come to the U.S. within 30 days, after 30 days of entry, and you adjust status or change the status or something like that, there is a presumption of fraud that you obtained the visa incorrectly. And then that lessened after 60 and 90 days, changing the burden of proof from yourself to the government to prove there was fraud. They updated the language to say, if you do a change of status, adjustment status within 90 days or do activities that reflect your intent wasn't to stay in the U.S., for example, on a B1 or F1 student visa, that presumption comes in immediately. that becomes a big issue, for example, if you're coming on a B1 and you get married after 60 days and file. Now, what are the consequences of that? There is a court case, there are court cases that say if you have an immediate relative and you come, like for example, a spouse, and you come and adjust status, unless there are other issues with the case, and I think it's a matter of Cabezos or something like that, there shouldn't be a problem with regard to adjust status if you enter on a tourist visa. So that should be okay there. But what happens now that they change the presumption? For example, if they got a B1 visa, they came to the US, got married, filed for adjustment of status, does the embassy then go, if they find out about it, invalidate that visa and do a claim of misrepresentation or fraud that then will come back to the adjustment saying you lied there? Is that what they're thinking is going to happen? There were synopses and interpretations I've read online about the harshness of it, and where they say might just be better to do consular processing in those kind of situations. I'm not sure if that's the case. The FAM is not regulation necessarily, and people do come and change their minds in the U.S. I'm not sure yet how it squares away. I'll definitely be talking about this in future podcasts, how that would affect people in the U.S. But another one that just popped up today is the residency abroad requirement. If you're filing for something like a B1 or F1 that says you have to have a residence abroad. So they added different language. Now they say, for example, F1 student visa requires an F1 applicant possess a residence in a foreign country that he or she has no intention of abandoning. That existed before. But then they add, you must be satisfied that the applicant intends to depart upon completion of the approved activity. Consequently, you must be satisfied that the applicant at the time of the visa application has a residence abroad, has no immediate intention of abandoning that residence, and intends to depart from the U.S. upon completion of approved activities. Now that must language is really high. It's an absolute language. It gives a lot of leeway of officers to deny things. So the addition of these languages it's part of, I think, administration's plan to make it more difficult. They've seen the games that have been played, and it's something to be mindful of. That means if someone applies for an F1 and maybe has a I-130 petition pending, even though it might be years in the future, that could create problems for them. Or if, for example, you're an F1 student coming for a 4 or 5 year university course in the U.S. to get a higher degree, if you know you're going to be in the U.S. for 4 or 5 years, you might not keep a home residence per se. Now you can have your parents' address as your residence abroad. That might be what you have to do. But if you know you're not going to be going home for 4 or 5 years in your home country, you might not hold on to a lease agreement and pay a rent for no reason. So how does that square away? I think it leaves a lot of room for interpretation and judgment on the part of the officer. It further goes, examining residence abroad. General rules for examining residence abroad are outlined in NIFAM 401.11-3 F2. If you're not satisfied the applicant's present intent is to depart the U.S. at the conclusion of his or her study or OPT, you must refuse the visa under 214B. So these changes, they're tweaking it constantly, and they're not making it as easy to notice these things. So you have to update yourself on the foreign affairs manuals. The one thing I do is constantly, every time I do a new particular case, or it's been a while since I read the foreign affairs manual, I'll go and reread it, because there's so much knowledge in there, and there's changes that are happening right now that you don't want to get caught. Now, the foreign affairs manual says one thing, the officers do another. I've seen many times where the foreign affairs manual said one thing, and to the benefit of the client, they've just made it easy and just accepted it. So it goes both ways, and they get away with a lot in consular processing. Interestingly, there's this website called Quora, where people, Quora.com, and where people post questions, and it's a mass answering machine for answers. And it's kind of like Avo, but it's just general about everything. And someone posted a question saying something about getting a visa requirements, all that kind of stuff, or how do the consular officials think about it? And one ex-consular post officer in the U.S. Had a thorough response saying, documents are worthless because people just make that stuff up, and officers do their best judgment. They don't have it out to get anybody. In reality, the part of visa processing is just something they have to do. A lot of people who do consular posts that work there don't go into to grant visas. They do it for diplomatic missions and all that kind of stuff. So it's a thing they have to do on the side that they just want to get out of the way. And the person who posted that answer also said most immigration attorneys are completely worthless and know what they're doing. My initial thing that hit me when she said that, when I read that from her, I didn't like it, but then, to be honest, I've seen the kind of garbage that comes out of our field. So I can't really hold it against her. I've seen a lot of dumb things happen by immigration attorneys. I think most people just dabble in immigration law and have no concept of the intricacies of it or how to deal with a consular post. and don't bother learning or reading the FAM to figure that out. So I kind of understand, but at the same time, I've seen a lot of garbage coming from consular officers as well, who they themselves aren't familiar with the Foreign Affairs Manual. I think the problem is just with the government making things way too complicated, where a person has to study years to be able to really understand and be on top of all these things, and it becomes very difficult unless they have that much experience to study in the field. Now, I did a couple of naturalization appointments this month, and some interesting things came out. I've talked about this before, where I go to naturalization interviews in San Jose, and at the end of the interview, they ask for 2 passport-style photos. Now, the USCIS stopped requiring passport photos as part of the processing because they said that, the biometrics you take, the pictures are sufficient. Their pictures that they take digitally are sufficient. But in some field offices, they still require. In Los Angeles, they don't require them. However, 2 points. After talking to the district this week, they said that if you're changing your name, you need to provide 2 passport photos because the name change for some reason requires that. Also, if the officer at the time of the interview doesn't think the pictures they took at the ASC meeting, the biometrics meeting appointment, is not good, they can ask you to give new passport photos. So the conclusion is this: although USCIS does not require 2 passport photos as part of naturalization applications, it's strongly recommended, it's what I'm going to do, to have clients bring 2 passport style photos with them to the interview, because if they go there and everything is good, everything's approved, but they request photos, you have to go back, get the photos, and then return, and they won't approve the case till that happens, and it causes an unnecessary delay. So although there's a cost to getting photos and bringing those, they may ask for them, they keep them. If not, the applicant can just keep it for themselves as a memory of how they look like when they became a U.S. citizen. But that's just a way to go to avoid hassle of practice tip. Going back to deferred action, as a practice pointer, I'm sure all of you, like me, are getting constant contacts and communications, emails, phone calls from people that have deferred action that don't know what they're doing now. My answer to all of them is unless they have certain special circumstances, that there's not much that can be done, and in fact, it's probably better to wait to see if Congress is actually going to do something. Now, this is not what I was going to talk about right now, it just popped in my head. I was listening to a political commentator, and they were saying that, because Trump gave 6 months for Congress to act, and the primaries are coming up at that 6-month point, potentially, where people are going to be running, and Democrats want to take over the House, all that kind of stuff. There might be issues in Congress where they don't want to pass that to ruffle up things, to get public animosity towards the Republicans so much to help the Democrats. So ideally, they would just come to a conclusion as soon as possible and create some sort of steps to make deferred action recipients and dreamers in general be able to have some sort of comfort and normal life in the U.S. But for political reasons, because the primary season is coming, you might see a lot of rhetoric and things that prevent a conclusion to that from coming up. So it might take longer, but at the very least, I tell them to wait. However, I didn't realize this until several times went by. Keep track of the people who are contacting you that are DACA recipients. If things do change, and for example, they develop a route for adjustment of status, keep the emails and phone numbers. You can follow up with these people when the decision is made to say, oh, by the way, you have an answer now, this is it, please come to my office for consultation. That's big business that you could be giving up, and I gave up for at least 5 or 6 people just telling you over the phone or email, sorry, I can't help you. Now, email, I have but I didn't keep good track. Maybe having a separate list of the people who contact on DACA with their name and when they contacted you, and tell them, I'll contact you again if any news changes. That's a great way. It's not solicitations because they came to you first and asked for help, and if they permit you, say, I'll contact you when things happen. So that's a business tip to definitely keep in mind. Now, on the last podcast, I talked about an issue I had with regards to co-counseling, how difficult it is for me, and I've never been able to do it, where if another practitioner comes and needs my assistance and wants to co-counsel with me, I'm just not able to do that because I can't partially do the work. Either I have to do all of it or none of it. But I was talking with a colleague, and they said what they do in this situation a lot of times is they charge their hourly rate from their attorney for advice. So whenever they hit a wall or need additional info, they come to you and you talk to them, which is good because only that'll take a few hours. Now, the hourly rate might be very high for me to do something like that relative to what a new practitioner would charge. For example, there was somebody that came to me with an EB-5 co-counseling a year ago, and they charged so little that like my hourly would have eaten up a bunch of it. They charged pretty much a quarter of what they should have charged for an EB-5 application, the complications that sort of petition has. So New practitioners that aren't aware might quote some unreasonable fees that might not make it feasible to do co-counseling where they pay for an hourly rate of another attorney. But that would be possibly something I would do. It still gets complicated because then I still have to go and dive deep and talk to the client potentially. But it's better than nothing for people to go and ask someone who knows it, like an L1 like I do, to talk to them about it to a certain extent, to get it going or to review their final product. In fact, with when they hourly fee it or something, providing extra documentation, cover letters, samples of things I have, and all that kind of stuff. So that might be the way to go. Now, moving on from that, there was this new requirement, unfortunately, they added for adjusting the status based on employment-based applications, which is adding an additional form called Form I-485J, which is an update as to the petitioners, employee petitioners, employment opportunity and employee numbers and income and all that kind of stuff to make sure everything is still up to par for the adjustment of status based upon an employment-based category. Now, one thing I do when I'm doing like an adjustment of status based on the EB-1C multinational application, because the I-140 doesn't have premium processing, it could take several months to process that. Who knows, it might not get approved. So until now, I never filed those concurrently. I would wait for the I-140 to be approved. Once it was approved, then adjust status. So that if the I-140 wasn't approved, the client wouldn't have wasted the money potentially. It might be the applicant, it might be their spouse and 2 kids. All of a sudden, that's 4 adjustment of status applications. That's thousands and thousands of dollars to do. If we file those and the file doesn't work out, that's a big loss for them. But one thing that happens is, if you don't file the adjustment in the I-485J with the I-140, you'll have to subsequently submit that. And sometimes there's changes in circumstances in employment that could be a problem. So I'm leaning towards filing all at once to avoid the additional follow-up with regards to like the company details, because certain changes that might be small may look a little bad or cause problems or cause additional review once it's submitted, which I prefer not happen. Now, if the company straight up doesn't match the requirements anymore, that could be a problem. It is what it is. But if there's small adjustments, I prefer not to do that. Now, that would have been okay until this requirement for having employee-based interviews got kicked in. So now that that exists, they're going to be reviewing everything all together. One pushback I get from other attorneys is like, they shouldn't re-adjudicate the I-140. They should just focus on the I-485. But the reality is, if a USCIS officer has a file, they'll adjudicate whatever part of it that they like. So everything's got to stay by the book and work completely till the end. But not filing the I-485J later, just filing at the same time might be the way to go if the client wants to pay the additional costs that are at risk if the I-140, the original I-140 petition application or petition doesn't get approved. So that's something to think about. Now, I want to end on some AAO decisions that have come out that had some interesting points in that I thought would help out. They're mostly based on EB-1 category cases. The first one is this. There was a national interest waiver case that came up August 11, 2017, matter of A-A-A-A-. I'm not sure what the 4th dash is for. But the job title was this: Senior Social Protection Specialist. And it was approved on appeal. So whenever people come to you for weird stuff, it could happen. Apparently, in this role, the applicant provides support to countries such as Egypt and Yemen through creation of social protection, labor, and community development policies and programs. So anything goes. They said that what the work that they did was important on a national scale and this and that, so that worked. And the person was established enough in what they did that they accepted it. So, sometimes job titles don't make any sense, but really do your research and they could work. You never know. The second one is the EB-1 case that came out for a person that did fencing. Now, for the awards, they had a bunch of awards from between the time they were 15 and 18, junior awards. And I'd always shy away from these because I've seen them complain saying these are athletics for kids, it's not sustained because they're adults, this and that. But AAO here says, an award or prize in a competition that is age-limited may still qualify provided it is nationally or internationally recognized. So it's not about the age, it's about the international and national recognition that they're pointing out. They actually have a citation here. It says, a footnote, it says, the question of whether an age-limited award or prize is indicative of a petitioner's sustained national or international claim, or that individual's status as being among the small percentage at the very top of the field, should be addressed in the final merits determination. So That's interesting. So you could get past the 3 criteria, but then when you get into the Kazarian analysis, that's where they get you. And that they did get this person. It wasn't approved, but they had bigger problems. But they approved a junior award. So, you know, you could, like, I have one case that I didn't want to even mention the junior stuff because I thought it would highlight that and they would have a problem. But they have adult stuff. So if you have adult stuff to show the sustain, might as well include the junior. Now the AAO says this. I'm not sure if the director at the USCIS, the lower level, they can accept that. But that's just something to think about. That was interesting. What they found fault here is that they didn't find fault. They accepted it because they said that junior competition was national. It wasn't a regional or university based or limited to a single university or a region. And that's where they find fault. Now, there are issues with that. I have athletes who do college NCAA that are top, and they win the top award in the region, but that's a very high level of competition. But, you know, it's one of those things on the line. I wouldn't rely on that for the award category alone. There have to be much more, something that's national and acclaimed on a national, accepted on a national basis. Like, for example, here they said, like, the newspapers covered this event that was so important, of the newspapers of that country. So that's just something, if you're an EB-1A practitioner, to think about. Another thing that came up in the EB-1A case was a case for a self-petitioning journalist. And the journalist apparently had submitted, with their counsel, documentation, for example, of articles written about them and this and that. USCIS did their own research and found those articles didn't exist in those magazines that were presented. And then the letters of recommendation about, like, their role and all that kind of stuff, they contacted the people that supposedly had written them, and those people didn't even know who the applicant was. So they got him on the journalist on a base of misrepresentation, which is horrible because USCIS is pretty good at not just throwing around fraud and misrepresentation willy-nilly, especially the AAO. They'll undo directors' claims of fraud and misrepresentation. They won't just say it, as opposed to maybe a consular post might be more likely to do something like that. But here they should have said, you know, the fraud review officer went and looked this up, and there was misrepresentation. We didn't find these articles that existed, and when we called the people that wrote letters, they said they didn't know you. So they do the research as necessary. Definitely be mindful, be careful, and follow up on your clients. Make sure to follow up their documentation, make sure it's correct, and really make sure they're not just making things up or something like that. Because at the end of the day, the likelihood of getting caught is high enough not to risk something like that. In general, we shouldn't be doing fraud anyways, but it's not like you're not going to get caught. Finally, there was a really good case here for an EB-1. It was a web application developer, an app developer. Now, when you think about the criteria for EB-1, usually, you know, extraordinary ability, you think actors and athletes and stuff like that. But this is the perfect category right now for app developers that are big in Silicon Valley. After reading this case, if I was in Silicon Valley and I had, you know, connections there, I'd be just making tons of money and taking on cases for Silicon Valley. Because when you think about the criteria, if they have articles written about them, so many of these, you know, big tech people have articles written about them. If they work for a big enough company and have some sort of leadership role, that's the second criteria that they get. And third, is that if they judge one of these awards, like, then there's so many different times where they have, like, people that are big in the industry or semi-big reviewing other people's apps and saying whether they're good or not, whether their code is good, this and that. You immediately take out 3 criteria. Now, when you think about the sustained acclaim, this and that, that's going to be the second level Kazarian analysis. That could be a problem for these kind of cases. But this case was approved. So based on that, I would definitely take on these kind of cases, especially if the client's, for example, making a lot of money and their stock options went high and really sound like they made a ton of dough. That's a 4th criteria, showing that you make more money than people in your field. So the app-based EB-1A category seems very promising at the moment. That's something I would definitely take advantage of if that was my clientele. Yeah, so hopefully that helps out people who are Silicon Valley, Seattle-based. I'm on Silicon Beach here in Santa Monica, and I do have those kind of clients, but they did a statistics, and they said that, you know, on the top 10 list of the big tech places, LA, and even though it has a name, Silicon Beach and Santa Monica and stuff in Venice, it's still like number 10. It's very low. New York and Seattle and obviously the Northern California region are much better. And there's a couple other regions too that are way ahead of Los Angeles, so that was weird. But these kind of clientele are there, and they're perfect clients for you to have. So definitely focus on that if you have a EB-1 base or practice, or your practice does include extraordinary ability cases. Potentially they can do NIWs as well, but I really love premium processing, and I like the fact that EB-1As have strict criteria. that makes it easier to explain yourself. Whereas national interest waiver, although they've tried to make it more specific and detailed, the criteria it has than it was before, which is a big help, it's still not perfect and it's time consuming before the I-140 is approved. So in a lot of cases, that might not be the way to go. That covers it for today. I was so happy to, that's about it for today. That's it for today. Thank you so much for listening again. Thank you so much for listening again. I always get great pleasure doing this and getting feedback from you all. Please stay in touch. My email is info@jqqlaw.com. I look forward to seeing you all again next week. Bye-bye.